Waqf Amendment Bill, tabled in the Lok Sabha on April 2, 2025, has ignited a firestorm of debate across India. This proposed legislation seeks to reshape the governance of Waqf properties, assets of significant religious and cultural value for the Muslim community. The bill, if passed, will usher in a new era of management and control over these properties. However, it has been met with a mixture of anticipation and apprehension, with supporters lauding its potential for reform and critics denouncing it as an infringement on religious freedom. The bill's introduction marks a pivotal moment in the ongoing discourse surrounding the administration of Waqf properties in India. Its provisions have sparked intense scrutiny, with stakeholders across the political and religious spectrum voicing their concerns and expectations. The government maintains that the bill is crucial for ensuring transparency and accountability in the management of Waqf properties. They argue that it will streamline processes, curb corruption, and ultimately benefit the Muslim community. However, opposition parties and several Muslim organizations have raised concerns that the bill represents an overreach of government authority into religious affairs. The debate surrounding the Waqf Amendment Bill is not merely about legal technicalities. It is deeply intertwined with issues of religious identity, community rights, and the delicate balance between secular governance and religious freedom in India. To fully grasp the implications of the Waqf Amendment Bill, it is essential to understand the existing legal framework governing Waqf properties, the Waqf Act of 1995. This act serves as the cornerstone for the administration of Waqf properties across India. It outlines the establishment and functions of Waqf boards at both the central and state levels, responsible for managing and utilizing these properties for the benefit of the Muslim community. The 1995 Act recognizes the importance of Waqf properties as not just religious assets but also as instruments for social and economic upliftment within the Muslim community. It empowers the Waqf boards to generate revenue from these properties, which is then utilized for educational purposes, poverty alleviation programs, and the maintenance of mosques and other religious institutions. Despite its aim to ensure efficient management and utilization of Waqf properties, the 1995 Act has faced criticism over the years. Allegations of corruption, mismanagement, and encroachment upon Waqf properties have surfaced, prompting calls for reform and greater transparency. The Waqf Amendment Bill, therefore, enters a complex landscape, inheriting both the legacy and the challenges of its predecessor. The bill's proponents argue that it builds upon the foundation laid by the 1995 Act, while addressing its shortcomings. Critics, however, remain skeptical, viewing it as a departure from the principles of community-led management enshrined in the existing law. The Waqf Amendment Bill proposes a series of significant changes that have the potential to fundamentally alter the way Waqf properties are governed in India. These changes touch upon various aspects, from the composition of governing bodies to the resolution of disputes, reflecting a clear intent to enhance government oversight and control. One of the most contentious proposals is the mandatory inclusion of non-Muslims in the Central Waqf Council and state Waqf boards. Another key change pertains to the resolution of disputes related to Waqf properties. The bill proposes granting a senior state government official the final say in such disputes, replacing the existing system of Waqf tribunals. This shift in authority has raised concerns about potential bias and erosion of the autonomy of Waqf institutions. Further, the bill seeks to modify the composition of the Waqf tribunals themselves. It proposes the inclusion of a district judge and a state government official of joint secretary rank, potentially altering the balance of power within these tribunals. Decisions made by these restructured tribunals would be subject to challenge in the High Court. The Waqf Amendment Bill also introduces a provision for the mandatory registration of all Waqf properties on a central portal within a stipulated time frame. This move is aimed at creating a comprehensive database of Waqf properties, enhancing transparency and preventing encroachments. However, concerns have been raised about the feasibility of completing such a mammoth task within the given time frame, especially considering the vast number of Waqf properties across India. The proposed inclusion of non-Muslims in the Central Waqf Council and State Waqf boards stands out as one of the most contentious aspects of the Waqf Amendment Bill. This provision has sparked outrage and accusations of interference in religious affairs from various Muslim organizations who view it as an infringement on their right to manage their own religious endowments. The government, on the other hand, argues that this measure is intended to promote greater transparency, accountability and inclusivity in the management of Waqf properties. They contend that the inclusion of non-Muslims will bring in diverse perspectives and expertise, leading to more efficient and equitable administration. However, opponents of the bill argue that the inclusion of non-Muslims in bodies responsible for managing Islamic religious endowments contradicts the very essence of Waqf, which is rooted in Islamic principles and traditions. The debate over the inclusion of non-Muslims highlights the sensitive nature of the Waqf Amendment Bill and its potential to ignite religious tensions. It underscores the deep-seated anxieties within the Muslim community about the perceived erosion of their autonomy and the increasing encroachment of the state into their religious affairs. Section 5. Dispute Resolution, Shifting the Balance of Power. The proposed changes to the dispute resolution mechanism for Waqf properties represent another significant shift in the balance of power under the Waqf Amendment Bill. By empowering a senior state government official to have the final say in disputes, the bill effectively diminishes the role of the Waqf tribunals, which were specifically established to adjudicate such matters. This move has been met with strong opposition from those who view it as an attempt to give the government greater control over Waqf properties and potentially influence decisions in its favor. Critics argue that involving a government official in what is essentially a religious matter raises concerns about impartiality and potential conflicts of interest. Proponents of the bill, however, argue that this change is necessary to streamline the dispute resolution process and reduce the backlog of cases. They contend that the existing system is often bogged down by delays and inefficiencies, hindering the effective management and utilization of Waqf properties, while the government maintains that its intention is to create a more efficient and impartial system. The proposed changes to dispute resolution have fueled anxieties about the potential for government overreach and the erosion of the autonomy of Waqf institutions. This aspect of the bill remains a point of contention and is likely to face significant resistance during parliamentary deliberations. Section 6. The Waqf by User Clause, a point of contention. The Waqf Amendment Bill proposes the removal of the Waqf by User Clause, a provision that has been a source of considerable debate and litigation. This clause allows properties used for religious or charitable purposes for an extended period to be recognized as Waqf properties, even without formal documentation. The government's rationale for removing this clause is to prevent the misuse and fraudulent claims of Waqf status over properties. They argue that the Waqf by User clause has led to ambiguity and encouraged encroachments as individuals and groups have attempted to claim ownership of properties based on informal usage. However, opponents of this move argue that the removal of this clause will disproportionately impact marginalized communities who may have been using properties for generations without formal ownership documents. They fear that it could lead to the displacement of communities and the loss of historical and cultural sites. The debate over the Waqf by User clause highlights the complex historical and social realities surrounding Waqf properties in India. While the government's intention may be to bring clarity and prevent misuse, the potential consequences of removing this clause, particularly for marginalized communities, cannot be ignored. Section 7. Digitization and audits, striving for transparency. In a bid to enhance transparency and accountability in the management of Waqf properties, the Waqf Amendment Bill proposes the digitization of records and the implementation of more rigorous auditing processes. This move is aimed at addressing concerns about corruption, mismanagement, and lack of transparency that have plagued the administration of Waqf properties for years. The proposed digitization of records would involve creating a centralized online database of all Waqf properties, including details of their location, size, ownership, and usage. This database would be accessible to the public, allowing for greater scrutiny and potentially reducing opportunities for fraud and manipulation. The bill also calls for more frequent and comprehensive audits of Waqf properties to ensure that they are being managed in accordance with the law and that funds generated from them are being utilized appropriately. These audits would be conducted by independent agencies, further enhancing transparency and accountability. While the push for digitization and enhanced audits has been generally welcomed as a step in the right direction, concerns remain about the capacity of Waqf institutions to effectively implement these changes. The lack of adequate infrastructure and technical expertise could pose significant challenges in transitioning to a digital system and complying with more stringent auditing requirements. Section 8. Political battle lines. A spectrum of reactions. The introduction of the Waqf Amendment Bill has drawn sharp reactions from across the political spectrum, reflecting the deep divisions and sensitivities surrounding the issue of Waqf property management in India. The ruling government has expressed confidence in its ability to pass the bill, citing its majority in both houses of parliament. However, the bill has faced strong opposition from various quarters, including opposition parties and several Muslim organizations. They have accused the government of attempting to undermine the autonomy of Waqf institutions and interfere in the religious affairs of the Muslim community. Some opposition parties have vowed to fight the bill tooth and nail, calling it unconstitutional and discriminatory. They have accused the government of pursuing a divisive agenda and attempting to polarize the country along religious lines. The debate surrounding the Waqf Amendment Bill has also exposed fissures within the ruling coalition, with some allies expressing reservations about certain provisions. The bill's passage through Parliament is likely to be a contentious affair, marked by heated debates and political manoeuvring. The government's determination to push through the bill despite opposition highlights its significance in their legislative agenda. Section 9. Conclusion. A bill with far-reaching implications, the Waqf Amendment Bill stands as a significant piece of legislation with the potential to reshape the landscape of Waqf property governance in India. Its proponents argue that it is a much-needed reform that will bring transparency, accountability and efficiency to the management of these valuable assets. They believe that the bill will ultimately benefit the Muslim community by ensuring that Waqf properties are utilized effectively for their intended purposes. However, critics view the bill with suspicion, seeing it as an attempt to exert greater government control over Waqf institutions and potentially marginalize the Muslim community. They fear that the bill, if passed in its current form, could have far-reaching consequences, impacting not just the management of Waqf properties but also the delicate balance of religious freedom in India. The debate surrounding the Waqf Amendment Bill is far from over. As the bill makes its way through the legislative process, it is likely to face intense scrutiny, opposition, and potential amendments. The outcome of this debate will have profound implications for the future of Waqf properties and the relationship between the government and the Muslim community in India.